San Diego DUI defense attorney: being arrested for driving under the influence can upend your life, but you have rights and options under California law. A conviction can result in license suspension, fines, jail, and a criminal record, yet the prosecution must prove every element. California Vehicle Code 23152 prohibits driving while impaired by alcohol, drugs, or a combination, and makes it illegal to drive with a blood alcohol concentration of 0.08% or higher. The legal limit is 0.08% for most drivers, 0.04% for commercial drivers, and 0.01% for drivers under 21. Penalties increase with each DUI within 10 years and include jail, fines, mandatory education, and license suspension. First offenses can lead to up to 6 months in jail and a 6-month suspension, while later convictions carry longer jail terms and multi-year suspensions. You have 10 days after arrest to request a Department of Motor Vehicles hearing to challenge an automatic suspension, and winning the hearing keeps your license but does not resolve the criminal case. Most DUI cases begin with a traffic stop for a violation or suspicion of impairment. Officers look for bloodshot eyes, slurred speech, and the smell of alcohol, and may ask you to perform field sobriety tests such as the horizontal gaze nystagmus, walk and turn, and one-leg stand. Field sobriety tests and preliminary breath tests are voluntary for adults, and sober people can fail because of balance issues or medical conditions, but refusing post-arrest chemical testing triggers a 1-year suspension under implied consent laws. Vehicle Code 23152, F, prohibits driving under the influence of any drug, including opioid painkillers, benzodiazepines, sleep aids, muscle relaxants, and stimulants. Common defenses include arguing that the traffic stop lacked reasonable suspicion, demonstrating that field sobriety tests were administered improperly, questioning whether the breathalyzer was properly calibrated, and showing that medical conditions or mouth alcohol produced false readings. The rising BAC defense points out that alcohol takes time to absorb, meaning your level may have been legal when you were driving but above the limit when you were tested. Prosecutors sometimes offer a plea to a wet reckless, which carries lower fines and little or no license suspension but still counts as a prior DUI if you reoffend. Commercial drivers who are convicted of DUI can be disqualified from commercial driving for at least a year with no option for a restricted commercial license during suspension. California's zero-tolerance law makes it unlawful for drivers under 21 to operate a vehicle with any measurable alcohol, and an underage conviction can suspend your license and jeopardize college admissions, scholarships, and employment. A DUI conviction stays on your California driving record for 10 years, raises insurance rates, hampers job prospects, threatens professional licenses, and can create immigration problems. Expungement may be possible after probation if no state prison time was served, but the record remains visible to law enforcement. Because the consequences are severe and the law complex, hiring an experienced attorney early can make a significant difference. A knowledgeable defense lawyer understands how prosecutors build cases, can challenge the evidence, and may negotiate for reductions or dismissals. The law offices of Anna R. Yum has defended clients throughout San Diego County, including the Central Courthouse, South Bay, East County, and North County, and this law firm offers free consultations. Call the law offices of Anna R. Yum at 619-233-4433 to discuss your case and protect your license, job, and freedom. Visit the law firm at 501 W Broadway, ST 1660, San Diego, California, 92101, United States to meet with a lawyer who understands San Diego DUI cases and will fight for your rights.